All right, everybody. Hi, Brian Parker again. Now on my stairs. I keep getting moved around because of the contractors in this place. As I said previously in my other videos, I was moved into my new house before it was finished renovating. Hopefully, and in some videos, you actually have heard the knocking and the grinding and the banging. So this one's at night after they just left. I'm on the stairs. There's the smell of paint in the air, but who cares? Today is the top 5 tips to beat Velocity Investments with their own documents. I'm holding right here the official show notes. This is probably the most show notes I've ever done for a production. So those of you that use my videos to fall asleep at night with, it won't be that long, I hope. But I'm going to do my best to condense this and hopefully it makes sense. So the Velocity lawsuit right now is one that is being sued by 1 or 2 lawsuits, at least here in Michigan, but it's nationwide. And it is a bunch of bullshit. Their own documents are so convoluted, and messed up that you should have a field day with this. The only thing in your way between you and victory is a judge not listening to you. And sometimes that happens. But after you hear what I have to say today and see what I have to say, when I taught my kids, when we went into the woods to learn about the woods, I'd always tell them, use your ears to see, because you can hear things better than you can see things out in the woods. Hunters, you know what I'm talking about. So we're going to be using words today to see things. And what I want you to know very quickly is the majority of these Velocity lawsuits are done on what's called, and I'm using their words, not true at all, an AI platform. So here's how it goes. A Cross River bank provides a high interest rate and a lot of money to the average debtor or borrower. And once that's locked up and the borrower receives the check, the Cross River Bank sends the debt to a secured trust. You're going to see the secured trust today in bill of sales, and they will come in different shapes and forms and names, but it's the platform generally that I want you to know about. I'll show you through documents today. So what'll happen is Cross River sells it to the secured trust, who's actually given all the money to Cross River to lend to the borrower. So now they give this debt, which has a high interest rate, lots of payments, to the secured trust. The secured trust that gave the money, this is securitization, but in a very simple form. The secured trust that gave Cross River Bank all the money to lend out is funded by bondholders who give all their money on different tranches depending on if the collection of debts have low credit ratings or high credit ratings. So if it's a AAA rated bond that the bondholders invested in, then it has good credit rating. Obviously, B, C's are lower and are greater risk, but there's a greater return. So it's your basic stock market philosophy, but this is how it's done. So now the debt is sold back to the secured trust, which has many weird names. We'll get into that too. And then a company called Upstart immediately contacts the borrower and says, hey, we're your servicer, you send all your payments to us. And that's used against you down the road. So in the case, the attorneys for Velocity will say to the court, hey, look, of course he owes it. He's paying Upstart. What's the problem here? Obviously, he owes the debt. So it's complete bullshit, too. By the way, this video is brought to you by America's coveted bullshit lawsuit of the year award. And we've got, as I said, a nominee today. And there are now, at this stage, we have the debt in the secured trust. Upstart Network shows up and says, hey, send us the check. Eventually, the debtor defaults. Velocity shows up and claims to own the debt now. And presents what's called a bill of sale. And the bill of sale says, remember we talked about how this debt was sold to a secured trust? It says the secured trust sells the debt, and they identify themselves as the initial seller and also one of the servicers. Remember we talked how Upstart Network is servicing the debt. And then for some reason Upstart Network's in that same small bill of sale, and they claim to be the initial seller and the initial servicer. It's just so convoluted. And then in that same bill of sale, the trust says we're selling it to Velocity. That's their basis of their lawsuit, that they own the debt. They're saying, hey, we're Velocity, so we get the right to sue. But that's not what's happening, because as you will learn, this thing is all about their bad paperwork. Their bad paperwork contributes to their nomination as the bullshit lawsuit of the year award. In that, the bill of sale, which is proffered as proof that Velocity owns the debt, is complete and utter bullshit too. Because while the bill of sale will say, in fact, why don't we do this? Here's an average bill of sale. And I'll pretend like I'm looking at the screen too. And as you can see in this first bill of sale, it shows an entity called Upstart Pass-Through Trust Series 2020 ST2 as initial seller and also as additional sellers. Remember again, the Cross River Bank was the originator of this whole thing. So how can Upstart Pass-Through Trust whatever be a initial seller or a servicer of something that just below this, Upstart Network in this bill of sale says they're the initial seller and the servicer, even though we all know Cross River, who started this whole thing, is the original seller, the initial seller. Unless the definition of initial has gone out the window and it's something else. I don't think it's that fluid. So I'll let you look at another bill of sale on the screen. Oh, I'm supposed to do this. Shazam! And here's one that says Upstart Funding Grantor Trust 2019-3 as initial seller, and on behalf of the additional sellers, and Upstart Network's the initial seller, has sold the debt. And by the way, they're not identifying the actual Smith debt or Jones debt, although they write some stuff on the bill of sale once in a while. So again, let's take another look. I'll look at another one, and then I'll give you the real 5-second crunch here. The Shazam third bill of sale, and you can see this one has Goldman Sachs Bank as the initial seller, an additional seller, and Upstart Network as the initial seller. Again, as we know, Cross River is the initial seller. In all three of those, I'm not sure if we can put 3 up on the screen, but we'll at least put 2, Shazam, Shazam. And if we can do a third, Shazam. Look at who is giving the debt to Velocity. It's these weird sounding trusts. But in order for them to do that, there must be a perfect chain of title. It's all about the assignments, baby. Where's the assignment from Cross River to Goldman Sachs, or from Cross River to these other weird sounding trusts? One has the letters ST2. I don't know what that means. In different years. But you have to have an assignment for a complete chain of title to this company for it to give the debt to Velocity. It's a simple chain of title. So what they all have in common, these 3 bill of sales, is that the initial seller is bullshit because it's not the weird sounding trust. And it's not even Upstart Network, who, by the way, is most prominent in appearance and maintenance of this debt with the debtor or the consumer. That's a given, but they are services until they ain't. But here, they're initial sellers, and they definitely are not. And the trust in each one of these bill of sales, by the way, they're all like this, says that they're the initial seller. And there's some other weird agreement. If you look at the top of the bill of sale, this is all done pursuant to the purchase and sale agreement. You never see that either. And there's a reason for that. So the number one way to get, oh, you know what I did? I forgot to identify what this video is. This video is the top 5 tips to get out of a velocity investment lawsuit. Number 6, it's the biggest bullshit going, but that's not number 6. So I'm sorry for not earlier announcing to that. And also that this video is being given, as always, under the auspices of education, entertainment, and research. And I'm trying to help you help yourself while not practicing law, and you're not my client in your jurisdiction, but I'm here to give you a bunch of stuff to help you on your way. And to identify one of the nominees of this year's Bullshit Lawsuit of the Year Award. Now, tip number 2 is that Velocity lawsuit says a company, Upstart Network, gave the debt to them, so therefore they own the debt. So if you look at the average Velocity complaint, Shazam, here's the complaint. You'll see around number 6 and number 7 that Velocity says, and I'll just read it, the Upstart Network pursuant to, it's on the screen, pursuant to the bill of sale. Remember the bill of sale we talked about where some weird trust is giving the debt to Velocity? Now it's saying in their own lawsuit, Upstart Network, pursuant to the bill of sale, assigned the debt to plaintiff. None of that happened. In fact, the Upstart aspect of that bill of sale makes no sense if they're an initial seller, an initial servicer, while the owner is Cross River. And the weird trust is saying that they're the initial seller, and on behalf of additional services and sellers have sold the debt to Velocity. So the Velocity lawsuit doesn't hold any water. But this is the first time, if you look in the lawsuit at number 6, the Cross River is mentioned, and the truth comes out. The debt is serviced by Upstart Network. And they claim that the rights of this debt were assigned to Upstart Network. All right. And then they say Upstart gave it to plaintiff, but there's no record of that. And take a look at that lawsuit. Shazam. There's no record of the bill of sale showing the weird trust that has already given the debt to Velocity. A real cool tip. This is number 2, but inside number 2, when you get one of these lawsuits, look at the age or the date of the bill of sale. It's always months earlier than the thing that they present showing you proof that Cross River Bank, months after the bill of sale, gave the debt to Upstart to do all this stuff, to give it to Velocity. Though months earlier, Velocity already received the debt supposedly from an assigned secure trust, and Upstart Network is somehow in there, but doesn't have anything to give until 3 months or 2 months or 6 months later in what they call their certificate of ownership. And we'll look at that very soon. If you look at number 6, it'll say certificate of loan sale. That occurred after the bill of sale. The bill of sale months earlier had given everything supposedly to Velocity. So how has anybody have anything to give to Velocity? And the bill of sale never has an assignment from Cross River or anybody else giving it to the secure trust to give it to Velocity, which didn't really occur because it already occurred, but it didn't already occur, yada, yada, yada. I could stop now, because that's it, that's the end. But there's some other bullshit going on. Let's take a look at that quickly on the screen. Shazam. This is the, what they call certificate of loan sale. That's in number 6. And you can see quite obviously nobody's giving anything to Velocity. Take a minute. There's nothing going to Velocity, and that date is always the 3/30/22. In this one I'm showing you, is always after supposedly everything was given to Velocity. So unlike what the Velocity lawsuit states, there's no proof of any of it anywhere. And if you follow the bill of sale, there's no assignment giving the debt to the weird equity fund secure trust. So that's what's going on there. For more help in this, you can look at my video, How to Defend Against a Debt Collection Lawsuit. I touch upon Velocity and an aspect of this, but today's video is exclusively 5 tips to beat a Velocity website. But it doesn't stop there. No, there's more bang for your buck. Another reason why this is a nominee for Biggest Bullshit Lawsuit. Oh, there's a new award. Biggest Bullshit Lawsuit of the Year award. They attach an affidavit from New Jersey. Usually it's a lady called Aliyah Rivera. I've deposed her. It's a fun experience because I never saw a human being look like a deer in the headlights before when you ask her basic questions about the thing that she supposedly signed and swore under oath were true. First of all, she doesn't write the thing, and she admits the lawyers just gave it to her. And in my deposition of Aliyah Rivera, which, by the way, quickly, no lawsuit is filed in Michigan as an account stated lawsuit. And generally, most collection lawsuits are, because they don't have the original agreement. So the Michigan legislature passed the account stated rule, MCL 600.2145, that allows you to attach an affidavit in place of the original signed cardholder agreement or proof of debt or indebtedness. So they add an affidavit from New Jersey. And the cool thing is they identify the debtor as a defendant and themselves, Velocity, as a plaintiff. So what? Well, this is signed, sworn under oath as true, and the affidavit is signed well before the lawsuit's even signed or written. So that's not true. Nobody's a defendant and nobody's a plaintiff. And they don't mention many of the actors I just told you about for this chain of title. This is their affidavit, so they can put whatever they want into it. And so instead of mentioning the secure trust, instead of mentioning all the other actors in this chain of title, they just put the plaintiff's predecessor in interest sold and assigned all the right, title, and interest in the defendant's Cross River Bank account to the plaintiff. Well, their own paperwork said Upstart sold it to Velocity. And then the reason why they say plaintiff's predecessor in interest, that's anybody else. The trust, the Cross River Bank. So they can fit this affidavit into any fact scenario as long as they don't identify the actual trust or the actual this or the actual that, depending on the debt. So she signed something under oath that's incorrect and frankly not true. It's quite an interesting thing that Velocity does this to itself. But again, it's the 9 out of 10 rule. Most debt collectors know that 85-90% of debt lawsuits are going to get settled early with fear and yelling at the poor debtor, or just ignored and defaulted, which is the number one goal. Again, Ms. Rivera's affidavit, which is from New Jersey, by the way, and is attached to every Velocity lawsuit that I've ever seen. Also, she admits she doesn't even work for Velocity. She works for the actual company called Velocity Group Portfolio or something that buys all this debt. And again, as you've heard me mention this, Velocity Investments appears to be a suing arm. I've never talked to anybody that works for Velocity, and she admits she doesn't work for Velocity. The fun I had in the deposition with her and the deer in the headlights was fantastic. And I'm not being a mean guy. They're saying things under oath that are less than true. They didn't even write the affidavit. They admit that the lawyers write it, so they just sign. It's not very nice. You don't break rules and do things like that. Just because the person got a debt, that's fine. We all have that responsibility to pay it. But this company has no proof it owns the debt and is now suing my client with BS stuff. I mean, really bad stuff. So that's your tip number 3, which is look at the Aaliyah Rivera affidavit from New Jersey, signed and sworn under oath well before the actual lawsuit is filed. So how does she know half this stuff unless she's just signing what they tell her to do? I have seen no proof that she signed this on the date she has. I'll take her word for that, I guess, because she doesn't have a history of not... Oh, wait a minute. Anyway, I'm assuming she did sign it and all of that. What I'm going to do is have some fun here. You can go and look at her deposition transcript. I'll put it on my Podcast Plus for free, obviously. Just dumping this if you want to do a little bit of extra work. But I will put on the screen now one of the most important parts of that transcript if you want to just get to the several good parts. But here's a good one. Shazam. And you can see, I ask her, just to reiterate what you said before, you've not seen an assignment or transfer of any kind to Upstart Funding, Grant, or Trust. So that's one of those weird trusts in those bill of sales. She says, correct. She says, I haven't seen the very thing that I'm talking about, the assignment that is necessary for this Upstart weird trust to give it to Velocity. I said, all right. Just for the record, the bill of sale was 5/26/2020, approximately 2 months before you called the web certification. Is that correct? Yes. So she admits that all this stuff happens before the stuff really happened, supposedly. I ask her, do you know what a chain of title is? She says, yes. Would you agree there's a missing link? This is their main witness. They go into battle with the complaint, with this affidavit, signed and sworn under oath. And their main witness says, do you know what a chain of title is? Yes, I do. Would you agree there's a missing link? Missing? Yes. The worst part, as an attorney, to not prepare your person who's going to be deposed by a jerk like me or any jerk like me, the attorney just left her out there. Hardly any objections. Very bad job. You can see. Go look at the deposition transcript. You hear nothing from him. That's either an admission that they've got a bunch of BS or it's a terrible attorney. I'm not having an opinion either way, but if you go look at my how to give a deposition, how to take a deposition, or how to protect your client in a deposition, I'm a different animal. I protect my clients. This is the opposite of that. She gave the farm away. She just, frankly, at this juncture, probably told the truth, that she doesn't see the stuff that they're claiming is there. So, if I didn't put it on screen already, it's there now, and then it's taken down, and I'm throwing it away. So, tip number 4, I hope, is best thing you can do with all this information, and it's more than enough, is sue Velocity in a counterclaim. So you'll answer, and more importantly, you need that affidavit from yourself or attorneys from your client. I've got a ton of affidavits on my Podcast Plus. I've got a video, how to write a killer affidavit. So everything that you will see, if it comes in your lawsuit, and it will, it's all the same crap, put it into your affidavit so the court can get the flavor of your case. Don't just write, admit, deny, blah, 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 blah. And by the way, a count stated lawsuit where there's an affidavit from the plaintiff, you have to do a counter affidavit in Michigan. Otherwise, you're just basically rolling over, and all that's really required at that point under statute is that they figure out how much you owe. So it's malpractice not to do a counter affidavit if you're an attorney out there, in my opinion, or anybody. Do not, is that double negative? Don't, it is now. You have to put an affidavit, a counter affidavit. Use everything I've given you. You'll see my affidavits. They're there for research. I'm not practicing law in your state, and you do whatever you want with them, you be you. But it's important that we snuff out this type of bad behavior from Velocity. Tip number 5, as always, it's all about the assignments, baby. It is. Where's the missing assignments? They're missing, of course. Their own witness who signed a sworn affidavit says, is there a missing link here? Yes. So what more do I need? It's about the assignments. As you can see, I'm not going to do this to you. Actually, I shouldn't say I'm not going to do this to you, but I'm going to show you a little something. Let's put tip number 5 on the screen. Shazam. And you can see it is all about the assignment. So if the lawsuits to believe, Cross River Bank to Upstart Network to Secure Trust to Velocity did not happen. If you take out the Secure Trust from the bill of sale, then it's Cross River Bank to the Upstart Network to Velocity. Did not happen. But with the paperwork that the debt collectors always give you, they just give you more rope to hang themselves with. It has to be like this. The bill of sale says the Secure Trust gave it to Velocity, but there's a missing assignment to the Secure Trust. If nothing is signed to Velocity in a certificate of sale, here's the reality. Cross River Bank gave it to Upstart Network, and nothing was assigned to Velocity. So there's, no matter which way you come at this, they can't win and you can't lose. This is a classic missing assignment case, and that's your tip number 5. It is all about the assignments. I'm probably tipping someone off, but this is another case where I'm gearing up for a class action. I see so many of these. This is more an accident. And they send you discovery, and I'll say, well, where's the assignment to the bill of sale? You have to have that. And they'll go, we don't have anything like that. In other words, they're admitting that they're suing on a lawsuit with a missing assignment, which is chain of title, assignment, lawsuit 101. You got to prove ownership. And they haven't, so they're violating Michigan laws of signing off on a complaint. So whether I sue Velocity and the law firm, that's why I haven't filed it yet. I'm thinking about what I'm going to be doing. But I need you to consider, folks out there, these are very important awards, these bullshit lawsuits of the year. I'm going to need your votes. So if you want to drop me a line saying Velocity lawsuit that you've seen, or you can see what I see after seeing my show notes and all the things on the screen and all the information I've given you, if you agree that this is the bullshit lawsuit of the year nominee, then let me know that. Also, subscribe. Look at all my other videos. There's 25 there, along with show notes, along with information, with account stated, answers, dispute letters, validation letters, securitization information, securitization answers. There's answers to so much stuff that you use as a guide. I'm not litigating your case, but lawyers and debtors, it's a great guide, a great way to get started and not feel like you're in trouble here. Because they're the ones bringing the biggest nonsense. And you've got to get right on it because you don't want to be defaulted. And this is a great opportunity for you to vote as to the nominee of the biggest bullshit lawsuit of the year award. Okay, tongue in cheek, but I don't think so. So subscribe if you like what I'm giving you. Comment if you want more. Comment and let me know if you want a video on something I haven't touched in 25, 26 videos. Again, how to defend against a lawsuit, how to dispute something in your credit report, how to validate a debt, how to go after private student loan companies. My big thing that I say every time, and I hope people's eyes don't gloss over if they haven't already, securitization. That will eventually knock out debt collection as we know it. By the way, this whole thing, this whole lawsuit and its nonsense is a direct result of securitization. It really is. The debt was securitized. Once that happens, they don't know what to do with themselves or to do with the debt or sue upon it. By the way, there are mechanisms in what's called a pooling and service agreement showing them how to fix all this nonsense, but the system is not set up for somebody to come along and take out John Smith's lawsuit and do all the things that the purchase and service agreement requires them to do. So they just, how do I put this, are just less than candid and just hope that the person defaults or the judge sees things their way, because judges are people too. They will say, well, I pay my debts, why isn't this guy paying your debt? Which is not the issue. It's my client, your client, does not owe the debt to someone that can't prove it and has not met their burden of proof. If you agree with me, like the video, subscribe. I got a ton of stuff. It's all free. Go get them, man. We're warriors together in this thing, going after bad guys like this. It's not nice what they do. I want to thank you for listening, and let's go get them. Thank you. Bye-bye now.